Some movement in the Bumpstock case that is going to involve the United States Supreme Court. Guys and gals, welcome back to Guns and Gadgets, the premier source for Second Amendment news. If it's Second Amendment news you're after, you have found your home. Hit that subscribe button down below and I'll deliver it to you every single day, oftentimes multiple times a day. So once you hit that subscribe button, turn the bell notification on to all notifications. And while you're at it, like the video and share it so more people understand what's really going on. I want to thank the sponsor of the video, that's CMMG. Can't show you anything. Last time I did, I got spanked by YouTube. But just know that CMMG is American made in Boonville, Missouri, and they make some long things and short things. Things that go pow and bang, some with rear surface area suitable for shouldering and some without. And speaking of, you go there, you can use my code GNG10 and save 10% off everything they make, everything they sell. That's a huge opportunity to save a ton of money with that coupon. GNG10, CMMG, thanks guys. All right, let's talk about what's going on. So the Bumpstocks, we've been covering this fiasco, this journey, since Donald Trump said, I don't want them anymore. And we all know this stemmed from the Las Vegas incident. We still don't have any questions answered. But Trump ordered his Department of Justice to ban bump stocks. So the Department of Justice and the ATF redefined machine gun to include a slidey piece of plastic as a machine gun. We all know it's not. And the fights ensued. Now, we've had several cases make it to high levels in the judicial system. And we have what's called a split in the circuit courts. For instance, in the 10th Circuit, the Firearms Policy Coalition case made it all the way up to the en banc decision, and they lost. They said that it's not a violation of the Second Amendment because it's a slidey piece of plastic, blah, 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 blah. And I'm just paraphrasing there, but it was a loss. And then we went to the 6th Circuit, where Gun Owners of America's case made it all the way up to the en banc full court, and they couldn't make a decision. It was tied 8-4 and 8 against. So that went back to the district court judge's decision, who said, hey, nope, sorry, no violation. So we had two losses. It was technically a loss and a tie, but the tie reverted back to the original loss. And then we have the 5th Circuit, where Michael Cargill, we've followed that numerous times here. Michael Cargill sued in Texas, and the 5th Circuit en banc court said, by a huge margin, it was 13-3, they sided with Michael Cargill. And the Cargill case sued based off of the violation of the APA. That's the Administrative Procedure Act. That's where you get a notice of proposed rulemaking, like the ATF did with frames and receivers and pistol braces and stuff like that. Well, they never did that for bump stocks. They just made a rule, made a change in administrative procedure that had teeth of a law, and made people criminals for possessing slidey pieces of plastic that were now ruled machine guns. Even though if put it in the corner all by itself, it'll never go off, it'll never hurt anybody unless someone has a plastic allergy. But here we are, and in the 5th Circuit en banc, they said that the district court judge should rule in favor of Cargill and then issue relief, but the district court judge never issued relief, just ruled in favor of Cargill, closed the case. And we covered that. And here's the problem. Michael Cargill says, hey, district court, you never gave me my relief. So the DOJ now, the Department of Justice, they have this scenario where they made this rule all willy-nilly. We have circuit courts saying, nope, it's a machine gun, we're siding with the ATF. And then we have a circuit court saying, no, we're not siding with the ATF. It's absolutely a violation of the APA because they didn't do the way they were supposed to do. They didn't post a proposed notice of rulemaking. There was no process at all. So now we have a split in the circuits, and that's typically when the United States Supreme Court gets involved. And here's where we stand today. Now, the 5th Circuit, the case is still going because Mr. Cargill, he wants his relief, right? And on March 28th, he filed for relief. So now the DOJ is saying, oh boy, the judge said we're supposed to give this guy some relief, and now he's asking for it. We need to stop this. So in the 5th Circuit, the Department of Justice has filed a motion for a stay to stay that decision, stay the win, hold it back, keep the gun control, because they're petitioning to the United States Supreme Court tomorrow for a writ of certiorari. They're asking the Supreme Court to take up the Bumpstock case. And this case is a violation of APA. It's not the straight Second Amendment case. This is a procedural violation. And when there is a procedural violation that violates law, it's supposed to be put aside. We've heard that a few times, right? In cases involving the pistol brace rule already. So here's the filing. Let's read it. It's very short, like 5 paragraphs. I want you to know exactly what's going on in this case because I get asked almost daily what's going on with bump stocks. Here we are. This is the motion to stay that the Department of Justice filed, in which they say what's going on. On March 28, 2023, the plaintiff, Cargill, filed a motion for relief under Rule 60, or in the alternative, under Rule 59, seeking a further order of relief from this court's entry of judgment for Mr. Cargill following the Fifth Circuit's en banc decision in Cargill v. Garland, which instructed this court to enter judgment. The parties dispute the nature of the relief that Mr. Cargill is entitled to should he ultimately prevail in this lawsuit, but the Fifth Circuit's decision in this case conflicts with the results reached in the D.C. Circuit, the Sixth Circuit, and the 10th Circuit, which each upheld the rule that Cargill challenges here. On or before April 6th of 2023, that's tomorrow, the government intends to petition the Supreme Court for a writ of certiorari in this case to resolve the disagreement among the courts of appeals. Should the government ultimately prevail in the Supreme Court, Mr. Cargill would not be entitled to any relief. In the interest of judicial economy and to conserve the parties' resources, defendants therefore respectfully move for the court to stay briefing on plaintiff's pending motion until a final resolution of the litigation by the Supreme Court. Counsel for plaintiff represents that plaintiff takes no position on the relief sought in this motion. A district court has broad discretion to stay proceedings as an incident to its power to control its own docket. The power to stay proceedings is incidental to the power inherent in every court to control the disposition of the cases on its docket with economy of time and effort for itself, for counsel, and for litigants. Here, a stay would substantially advance the cause of judicial economy. The issue to be raised in the government's petition for certiorari, specifically, whether a bump stock device is a machine gun within the meaning of 26 U.S.C. section 5845B Bravo, is likely to be dispositive of the plaintiff's pending motion. If the Supreme Court grants certiorari and rules that the statutory definition of machine gun does not include bump stock devices, the parties will likely be able to agree on the appropriate relief in this case, and the Supreme Court's determination of the scope of the statute will be given nationwide application. If, on the other hand, the Supreme Court reverses the Fifth Circuit's decision and rules that bump stock devices are within the statutory definition of machine gun, then plaintiff will be entitled to no relief at all. In either event, the court's premature determination of whether or what additional relief should be ordered is likely to be overtaken by the Supreme Court's ultimate decision if it grants the government's petition. It would be inefficient to continue proceedings in this court while the matter is under review by the Supreme Court. Parallel proceedings in this court would result in unnecessary expenditure of the court's judicial resources and potentially result in interim rulings that would require subsequent modification or reconsideration in the light of the appellate proceedings. Let's jump to the end here. A stay will not unduly burden the parties. Plaintiff is not and has never been subject to enforcement proceedings under the bump stock rule and faces no imminent threat of such proceedings. And although plaintiff takes a broad view on the legal remedy to which he would be entitled if the Fifth Circuit's decision becomes final, he is not entitled to treat that decision as final until the government has availed itself of the appropriate appellate avenues. Indeed, the parties would be burdened more if the court were to treat the Fifth Circuit's decision as final during the pendency of those proceedings and enter some relief that would ultimately have to be undone or corrected. The better course, therefore, is to stay further district court proceedings. This stay would promote the interests of finality, justice, and judicial economy by permitting the parties to obtain a final answer on the underlying statute question from the Supreme Court. And if the Supreme Court denies the current petition, the parties can brief the appropriate relief at that time with the understanding of what statutory construction is binding in this circuit. Accordingly, defendants respectfully ask this court to stay district court proceedings until appellate proceedings in this matter are fully concluded. So there you go. The Department of Justice, the U.S. government, is asking the Fifth Circuit, please, let's pump the brakes here. You know what? We're going to ask the United States Supreme Court to take this up. And if they take this up and they rule that bump stocks are not machine guns, then everybody knows, the whole country will be under the same rule and will be able to give Mr. Cargill whatever relief the court decides is just. However, if the Supreme Court takes the case and says bump stocks are machine guns, well then, we all know that what's going on will stay, and then Mr. Cargill will get no relief. Now here's the rub. If the United States Supreme Court denies the writ, well then the Fifth Circuit en banc's decision would stand, obviously, and Cargill would be entitled to relief, which would keep a split in the circuits, and that's typically not what the Supreme Court wants or allows. So, as a result, the probability of the Supreme Court taking this case is actually pretty favorable. Now, nobody can get inside the Supreme Court justices' heads. This writ will be submitted. It'll be passed out. It might not be, as we've followed here numerous times on Second Amendment cases. They could just kick that down the line every month, and it may or may not get a quick answer. However, when it does get an answer, I will have it here for you. So if you want to stay up to date with this case, the Bumpstock fiasco, or the pistol brace fiasco, or anything else related to the Second Amendment, then subscribe to this channel down below. Just hit that little button, hit that like button, and turn the bell notification on to all notifications, and I'll keep you in the loop. Guys and gals, thank you so much for your time. Until we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all in the next one. Take care.